Salter Teillet, Senior Consultant, and he's part of this group. And he specializes in indigenous law, indigenous rights law, with the emphasis on the community-based process and government-to-government negotiations. As before, he has served as a chief for 4 consecutive terms. That's quite an accomplishment. I only lasted 2, and I was only a speaker. Yeah. Don't worry, you're not the only one that gets arrows in your back. He's done a lot of work in the with environmental matters, and he's here with us today. And Randall's received his BA honors from York University and his LLB from University of Toronto. And in the middle, you got me a little confused with this a little bit. There's Shiri Pasternak.
That's right.
Ah, first one I got right. Give me a round of applause. And she's an assistant professor at the Ryerson University. She's also a research director with Yellowhead Institute. Welcome. And we all know Russell. Russell's here with us, and Russell's an advocate, and he's also stepped forward and ran for the national leadership for the AFN. I've been reading Russell's work for quite some time. It's got me thinking a lot, in particular because a lot of the stuff that he writes about our rights and things is what grassroots people ask me. And they constantly ask me these things because they keep life very simple in regards to the understanding of who we are. I can't say traditional sense because it's not traditional. It's been B'madzuin. It's been the way of our life. Because a lot of our grassroots people just look at they don't look at the global parts of it, because well, we never had too much. When we were growing up and going to school, we only had like 2 channels on the res, and that's with rabbit ears. But the information that comes out, they put their faith. We put our faith in our elected members and council, but we also know who our traditional people are. And we're very fortunate that the people in our community that sit on the chief and council do have hereditary blood in them, but they find themselves in a quandary because they're working within that framework of the Indian Act. But we kind of throw it out because at the same time we work within our own. It's called, Russell reminded me about that word yesterday, our constitution, Chinakanegad, because we formulate that from our grassroots up, and we still have discussions about how those things affect us, and we constantly remind our leadership about those things. But a lot of our leadership, they know their clan, they know their family history and so forth, and it's been somewhat of a balance for them, a hard balance, because I'm assuming that most communities are the same way, but we struggle with working that framework. So Russell's done a lot of work, and if you were in his workshop yesterday, we got a history of it, and that was important, because we got to go to the beginning. Just like when you go into a lodge or ceremony, they're going to share that with you, and it's going to constantly remind you, because you're going to learn something from that, which you may think you might know everything, but you don't. So when you go into ceremonies the same way, you have to start from the beginning, and to remind people. And when you do that, you also have to take in the fact, like that Eagle staff should be there to remind us and those sacred items that we bring in. And that reminds us to speak in a good way and to be thoughtful and bring that consultation together. But it is very difficult because the mindset, of living in two worlds is something that our young people are striving to understand, as educated as they've become. That understanding of that original way of thinking, they yearn for that also, so they need to find a balance themselves. But the realities of it is that the confusion, when you looked at the map, if you look at a map of Ontario, and you look at it's a Robinson here, there's different trees, Robinson Huron Lakes, Robinson, Superior, Williams Treaty, and so forth. You look at those treaty areas, and then you look at the size of the First Nations communities, really awakens the young people's eyes, and then they struggle with, when we talk about free, prior, and informed consent. They talk about Crown land, and they talk about, it's a hard concept because we are still responsible for that area. And so it becomes a little bit foggy for our people. And then you look at the other side, the provincial government, federal government. We're always taught that we work with federal as nation to nation, building nationhood. And the young ones that come and see me that I've taught, they ask the question is, do they know their history? Do these Canadians know their history? Because Canada is a state, and they recently, they didn't accept, but they acknowledged the United Nations Declaration on Indigenous People. But Canada was one of the states that wasn't for it prior. They voted against it at the UN level. And our Anishinaabe people have always been going over and talking to them, and even to the Crown, Britain. So this history that our young people are learning and are fascinated by it, ask that question. And I tell them, I says, well, no, Canadians just know themselves as Canadians. Because I've come across young people and I've asked them, I said, what's your heritage? I'm Canadian. No, where are you from? Canada, Toronto. No, where are you really from? Oh, I got a little bit of Scottish, or they might say French, or whatever, eh? Or they say Heinz 57. I don't know where that ketchup. You're not ketchup, But, and then I asked them, do you speak your language of your people? Yeah, I speak English. No, where you come from? Even to the point where West Indians, East Indians, and so people that are immigrants, that have come here, second, third generation. And they asked me why. And I says, well, you're Canadian. Wouldn't you call yourself French Canadian like the French do? I said, we don't call ourselves Ojibwe Canadian. And they say, why not? How come we don't? I says, because we haven't been acknowledged yet. We haven't been given that acknowledgement. So these young people, I'm talking high school, and they yearn for this knowledge to understand it, because they don't know how come those treaty rights are not being adhered to, and it confuses them. And sometimes we get lazy and they don't fight for their right, or they don't stand up for their right, but some do. And the ones that do now, when we see them on TV, you have to really visit them to see where they're at. But a lot of them will say is, I just know I have to be here. So this is a good opportunity, and the reason I share this is to set up the framework for our visit here, because how we look at the free, prior, and informed consent. This conference here this is historical breaking, because we have a vast responsibility now in the treaty area, you know, and we need to educate Canadians of our understanding of what our responsibilities are. I hope that makes sense. If it does, raise your hand. Okay, I'm really going to get your hands up there because I have telekinetic powers. No. So let us begin. And I didn't mean to dampen it, because it is a interesting topic. It can be dry sometimes with all the jargon and so forth, but this is the time to ask those hard. There's no such thing as a bad question or stupid question. Don't worry about it. I'm the one that's hired to look stupid, okay? It's my job, not yours. Aha, kamachitame. Let us begin. First, all right, right in the back, Mike, get Mike. Oh, Mike changed, gender change. That happened fast. Good morning.
Thank you for inviting me to your conference here. It's been spectacular. I know some people of the Iroquois Confederacy. There are 15 of them that spent 21 years in the United States court system and got no fair trial, no due process, and no justice. They want to go to The Hague. They've been through the Supreme Court of the United States, got no relief there, and they want to go to The Hague. They want to rely on the UN Declaration on the Rights of Indigenous People. And they've been unable to talk to anybody at the United Nations or the Hague that will assist them on filing their application. Can somebody tell me how they might be able to get the ability to file under the Declaration, which protects them, how they can get to The Hague and talk to people at the UN on the, particularly the permanent forum on indigenous issues. They're unable to get past the operator. Thank you.
That's a good question. Who would like to answer that?
First of all, the UN Declaration is just that. It's a declaration that's been voted on by the General Assembly of the United Nations. There is talk about pushing for it to become a full covenant, you know, like the Covenant on Civil and Political Rights, or the Covenant on Social, Economic, and Cultural Rights, which also apply to Indigenous peoples. But, you know, this issue of going to the World Court, I hear a lot of our grassroots people always saying that. How come we don't take Canada to the World Court? Well, for one thing, under the United Nations system, the only ones that can bring an action forward under the World Court is a state party. So that would mean you'd have to get a government in the world, somewhere in the world, to do that. I don't know if Bolivia is ready to do that. They have an indigenous president, Evo Morales, but I don't know if he's prepared to take a case to court against Canada or the US, because certainly would affect their trade relationships and stuff, right? It always comes back to the global economic system, right? So there are other mechanisms in the UN. You know, there is the United Nations Permanent Forum on Indigenous Issues, but that's increasingly kind of becoming a gate to blocking our issues at the UN system, because in 2014, they had this, what they called a World Conference on Indigenous Peoples. And there was a big debate about that. In North America, we had the North American Indigenous Peoples Caucus, NAPIC. And every year before the UN Permanent Forum met, we would have a caucus meeting somewhere in Canada or the US, because North America involves Canada, the US, and Mexico. That's the definition of the North American region. And so we had representatives of Indigenous peoples come to that caucus and get their issues out, and then we would report on those at the Permanent Forum every year. But what we were finding, well, the problem came up in 2014 when the United Nations said they were going to have this World Conference on Indigenous Peoples. But it wasn't really a World Conference because it was only for one day. Normally a World Conference on whatever issue is a week. And so we had a caucus meeting in Kamloops, and we were saying, well, if the United Nations is holding this World Conference on Indigenous Peoples, and the General Assembly's adopted this United Nations Declaration on the Rights of Indigenous Peoples, then we should have an Indigenous co-chair to run that World Conference, if they're going to respect the Declaration within the UN system itself. And the President of the General Assembly of the UN said no. They were going to appoint somebody from the United Nations to chair the conference. So in other words, they were representing the state governments, you know, and they weren't going to accommodate Indigenous co-chairmanship of that meeting. So as a caucus, we recommended boycotting that meeting. And once we did that, then the establishment organizations like the Assembly of First Nations, National Congress of American Indians, even the Haudenosaunee Confederacy, some of them said, no, we're going to go to this World Conference. But in order to get into the World Conference, you had to be recognized by a state government or you couldn't get in. You can't just walk in. You have to have credentials. And the only ones that can give you credentials are the state government. Like in Canada, you have to be recognized by the Canadian government to say, okay, you can come and say you're representing Indigenous peoples. So they limit your participation in the process, right? Because the United Nations controls the rules, right? That's what we have to remember, is that the United Nations is a huge bureaucracy and its structure. It has these international covenants that they're implementing, especially around human rights. And the World Court is only one part of it. And by the way, Trump and his government just announced the World Court, right? Because they don't want the United States accountable to any of these bodies. So it's complicated when you start talking about this international law and moving forward using the Declaration. Because just to finish on this World Conference on Indigenous Peoples issue, there was an outcome document that came out of that meeting, and they didn't even mention, they mentioned free, prior, and informed consent, but they didn't mention self-determination at all. And as I said in my presentation yesterday, to me, the most important part of the UN Declaration is Article 3, which says Indigenous peoples have the right to self-determination. Without that, the rest of the articles, I think, don't really mean much. And so they didn't mention that in their outcome report of this World Conference on Indigenous Peoples. And one of the things they did include in that outcome document, and it's available on, you know, you can search for it on, you know, the web. If you Google World Conference on Indigenous Peoples, you'll get the outcome document. And it did call on the state parties to all develop national plans. So that's what Canada does, this reconciliation framework they're talking about. They're going to say to the United Nations, this is our national plan that we've been working on how to implement the UN Declaration. So that's what that World Conference was about, was how are all these state parties going to implement the UN Declaration? But the United Nations hasn't named anybody to monitor how state governments are implementing the UN Declaration. You know, about are they respecting free, prior, and informed consent or not? They have the United Nations Permanent Forum, but like I say, they're kind of a gatekeeper for our issues. They're kind of blocking us because the United Nations has adopted this thing called SWAP, the System-Wide Action Plan. So they're trying to limit Indigenous participation in the UN systems. And if you register to go to the UN, you're registered under an Indigenous Peoples Organization. So that's a status that they've designated at the United Nations. They're talking about splitting that, whereas you represent an indigenous government, you might have a different status, but you're still like an observer status because you're not a state. The Palestinians have a higher status than indigenous peoples do because they've been pushing for recognition as a state. And they've given them a status in the UN where they can get into most meetings with their credentials because they're just short of being a state. But they've fought for years and years and had international support. Our people really only started fighting recently in the 1970s at the UN system. And then in the 80s, they started working on the UN declaration. So it took from the 1980s till 2007 to get that declaration out. And that declaration, the government calls it aspirational because they're saying it's not legally binding. But in my view, it does represent the minimum standards on human rights that apply to us. And I think we need to use it as a framework to say that Canada's domestic policies, that there's a big gap between the standards of the UN versus what they're applying under Canadian domestic law. And just to finish up, I'd say what we need to start doing is looking at using different human rights bodies over there, like the Committee for the Elimination of Racial Discrimination. A lot of us go over there and make representations to them, and they make recommendations criticizing Canada. There are human rights bodies we can go to as well. And they do have a special rapporteur on the rights of indigenous peoples. Vicky Talis Corpus, her name is. She's from the Philippines, but it's her job to go and visit and do country reports and stuff. So they can all make recommendations to the UN, but we don't have access to a court system to judge Canada at the UN. But we can embarrass Canada, and we can document how Canada is treating us. And that's why Trudeau went to the United Nations to make a speech, I guess it was a year ago. He went and said that he admitted Canada had colonialism and didn't treat indigenous peoples well, and he told the General Assembly that they were going to do better. So Canada is vulnerable to criticism of these human rights bodies at the UN and that. And I think we have to use that more. But instead of going to court, I think that's not going to be possible to go to the World Court, not in the immediate future. So I hope that clarifies it a little bit. I don't know if anybody else wants to say anything.
Well, it did. I just, in my view, what you said, Russell, is, in my view, the declaration is a sham, meaningless, because indigenous peoples can't use it. And it's something for the United Nations to show the world, look how we're assisting and trying to assist and help indigenous peoples, when in effect it is no bearing whatsoever because indigenous peoples are shut out. I find it unfortunate, and I would hope that the indigenous peoples would rise up all over the world and say, we want to be recognized in the United Nations, and we want, when we call and we want to file something and we want to go to your court. And it's the principal organ, judicial organ of the United Nations is the International Court of Justice, and they should hear them.
Just to respond, if I can.
Thank you.
Just quickly to respond, I would say, I wouldn't call it a sham. I mean, it is the minimum standards. It could be better. But, you know, there's hundreds of millions of indigenous peoples around the world that pushed for that declaration for, 20 or 30 years for the UN to adopt it. There was a lot of work put into it by indigenous peoples themselves. And I would say you're right. I think it's us as indigenous peoples that have to push the United Nations system more. But we have to get our acts together on the ground. Yeah. That's what I think. If we don't get our act together on the ground in our communities at conferences like this, to get organized, what the environmental office is doing with the two communities here, that's how we got to build things up from the ground up to the international level. And the more organized we are in our communities and better able to say what we want, what our vision is, what do we mean by free, prior, informed consent, the better we're able to articulate that to the provincial, federal, and international system. So I think the burden is on us to get organized to push it, because we were the ones to push for that to be adopted in the first place. And yes, it's up to us to learn what the articles of it. I noticed in the kits you guys handed out that little booklet. it's very important for you to learn what it says in that booklet because it lays out all the articles of the Declaration.
Yeah.
And we all need to memorize that and start comparing what's in those articles comparing to what the Ontario government and the federal government are doing to us. Because there is a big gap and we need to be able to show what the gap is. And I'm not talking about socioeconomic gaps like the national chief. I'm talking about the gap in our rights, our rights to lands, territories, and resources. Those are the key rights we have to address.
Yeah.
That's what I think. That's where our poverty comes from, is the fact that we've been put on these small reserves.
Yeah.
And we need access to our larger territories, like you were saying, Chris. Thank you.
Miigwech. So, all right. We have a young lady in the, oh, okay.
I'm just wondering how we can use the United Nations Declaration, but then there's Article 46 in there that kind of contradicts all of the articles before it.
Could you repeat that one more time? I'm sorry.
How can Indigenous communities use the United Nations Declaration on the rights of Indigenous people, but still, if you read through it and then read Article 46, you'll see that it's really given a lot of power to the state. How can we use this document to empower our people, but then there's that clause at the end, Article 46.
Yeah, that last minute change. Who wants to take a stab at this one? Okay.
Okay, that was a clause that was put in, or a section of the UN Declaration that was put in at the last minute. Some Indigenous peoples that were at a meeting in New York, I understand, agreed to it because they wanted to get it put before the General Assembly. Because, you know, there were countries, like the African countries, that didn't want it because they were afraid that if tribal peoples in Africa started to be recognized under that declaration, they'd start to ask for their states to be broken up into territories. And other states had the same concern that, you know, if we recognize Indigenous peoples, they're going to say they want, you know, to break up our countries. So they put that clause in there. And, you know, the late Arthur Manuel and I used to talk about that a lot. And we said, well, we still think, even with that clause in the Declaration, that we can still say that Canada has to restructure itself, you know, federally and provincially. You know, right now Canada keeps saying that the constitutional framework is going to remain in place. That means the federal and provincial orders of government and their jurisdictions, and there's no room for us. We've always said, well, Section 35 needs to be interpreted. If they need to bust open the Constitution again, because Section 35 was supposed to be a political agreement. When they brought that new Constitution back, those talks in the 1980s were supposed to lead to a political agreement about what do Aboriginal treaty rights mean in the Constitution. Those talks ended in failure. You know, Meech Lake, Oka, everything else happened after that. They stopped talking about the Constitution. The courts started taking over and interpreting Section 35 and limiting it and putting legal tests on, which cost millions of dollars to meet. And so now, really, the burden of proof is on us to prove we have rights. And it's really an unfair process legally because most of us can't afford to seek justice under such strong legal tests. So there still is a lot of room, I think, to call for fundamental change in Canada. It's probably going to require constitutional change ultimately. But there's nothing stopping the government right now. You know, they're trying to come up with this framework on recognition and implementation of Indigenous rights framework. They want to pass a law in Parliament, and it's just the federal government. The provinces aren't involved. So why don't they have the Prime Minister sit down and have a meeting with the premiers and representatives that we choose to start talking about, it might not have to be a full constitutional conference, but it should be at that level, I think. The heads of these governments need to sit down and talk about how are we going to be recognized and accommodated, you know, in this United Nations Declaration in Canada. But instead, everything's being done in secret so that Canada's acting like Section 46 is the be-all and end-all, that they can just unilaterally decide things. And unless we challenge that, that's the way they're going to continue to act. So I think the other articles, because the Declaration has to be read in total. You can't just read Article 46 by itself. You have to read the whole thing, and it says we have the right to self-determination. We have land rights that should be restored. If they're not being restored, they should have restitution. We should be compensated. And there should be a fair process to adjudicate it. So there's a bunch of things a bunch of articles in there that we should point to too, to say we need fundamental change to the Canadian system. We can't just focus on Article 46. That's what I would say.
Miguel Russell. You should. Good. Would you like to add anything to it?
I would just add, I think words mean something, or they have to mean something. And when leaders use words, they have to be accountable for those words. Many of you may recall, shortly after the election, the Prime Minister said something that was very distinct. He said, "I want a renewed nation-to-nation relationship." So when you think about that clause and you think about that statement, does Canada really know what that means? And how is that defined? And I think that's a door that we need to kick down and say, if there's going to be a renewed nation-to-nation relationship, then here's the terms on which that relationship is going to look. And, you know, we look to our treaties, and, you know, we have such an impoverished view of what our treaties are in this country. Often in history books, or even by the courts, they're reduced to simple transactions. And that's the furthest from the truth. When you think about the sacrifices our ancestors made to protect what was important to them, first and foremost was that relationship to the lands and the waters, to ensure that that would sustain them. It wasn't a document that would, in essence, give up all this land and we'd be resigned to these little pockets within our territory. That's not the case. And we know the efforts that Canada made over many, many years to marginalize us and keep us from those lands. And, you know, when we think about first principles about treaties being nation to nation, predicated on mutual respect, and that neither is to interfere with the path of the other. How is Canada's actions consistent with that understanding? So when I think about that clause and I think about what the Prime Minister has said, he has to be accountable for that. But that's work, I think, I agree with Russell, that's work we have to do for ourselves internally within our communities, to pick up those tools we have and build our nationhood so that we're ready for those things and to take those things forward. You know, when Harper was in office, you knew what you were going to get. And I remember we were in a meeting one time and someone asked me what I thought. I said, "Oh, I think Harper's a breath of fresh air." And I got a lot of bad looks. I said, "But let me tell you why." I said, "Because at least everything you know he's going to do is going to be to screw you over." So why are we reacting to what he's doing? Let's be proactive. Let's take the steps necessary to occupy the field. You don't want the Indian Act to apply? Implement your own laws. You don't want certain aspects to be applicable in your territory? Build that out for yourselves. Do the land use planning. Build your protocols. Build those things up so that you're in a position to make that stand and implement those things effectively, so that when the time comes, you're in a good position to challenge those things. And I think that work is so important because I know I'm a lawyer by profession, but if you're relying on the courts to do that work for you, you're going to the wrong place. And the courts are a blunt instrument. Sometimes they get it right, sometimes they get it wrong. But as far as I'm concerned, as long as we are in a country that's legal system is still predicated on things like the doctrine of the discovery, then we've got to do that work for ourselves and be prepared for that. So I would add that piece to it.
Shiri, would you like to add to that?
Russ is prodding me to talk about consent and what it could mean in the face of that clause in UNDRIP, and to pick up on some of the comments that Russ made, I know, yesterday about the importance of land use and occupancy planning to meet those thresholds for strength of claim, and also picking up on the previous comments about those land use and occupancy maps. Like, I guess the question is, how then do you use that information and that research to assert an idea of consent that comes with conditions that make consent meaningful so that it can't be co-opted? And some of the things that could be attached to consent would be the resources for communities to develop that technical capacity to do the maps, which a lot of communities don't have the resources to do. You could attach the meaning of consent to having resources to research cumulative effects of mining, development, and other kinds of incursion and land alienation on your territories. Because without having cumulative effect, what does consent mean if you don't know what the impacts have been already on your lands? You can't make an informed decision about what more impacts the land base and the watershed can handle if you don't have any sense of what's come before. And then third, governance capacity. So partly the problem with the consent regimes or the consultation and accommodation is that they're happening on timelines that are just draining the time and energy of communities into these endless processes that don't allow communities the time and the resources they need to develop governance capacity to determine what their process should be around how to deal with development in these letters like that pile up on band council desks. Mm-hmm. And so if we talk about consent and pushing back against the government's assertions of authority and push back with other ideas of consent, then we have to, I think it's important also to think about what kind of conditions could be attached when people talk about consent that would actually make it meaningful. So unless those conditions apply, then communities could push back and say, this isn't meaningful consent. This is just consultation with no outcome other than ministerial discretion or provincial authority, unless we have these things built into it.
Miguel.
Just add one thing on that too is, this governance and addressing consultation and accommodation versus consent, we have to reorganize ourselves, our own governance structures and the way we interact with our people, because it's not just the chief and councils and the band offices. Yeah. Self-determination belongs to the people. Yeah. But we have leaders in there that, have to go forward and advocate for us. But they also need direction. Mm-hmm. And they need to restructure themselves, because the thing I say is Article 18 of the UN Declaration says that Indigenous peoples have the right to make decisions through their own Indigenous institutions. And bands and band councils are not Indigenous institutions. Then Article 19 talks about the government's negotiating with Indigenous representatives on changes to legislation and administration. So that's what Trudeau's doing. He's talking to AFN and the other national Indigenous organizations using Article 19. But what's being left out of the picture is the people. The people need to come up and do assemblies outside of the Indian Act structures to get involved in decision, because in a lot of ways, our people stopped being involved in decision-making because there was the Indian agent that told us what to do. Mm-hmm. And in a lot of ways, the chief and council kind of just took over from the Indian agent to deliver programs and services by Ottawa, and kind of did the same thing where they said, okay, the chief and council will decide this. And maybe there'll be a band meeting once in a while if it's a decision we think is bigger. But even under the duty to consult, I've seen bands, I won't mention them, but there are some bands that have economic development corporations, and the chief and council would say, okay, we're going to put the responsibility to do the duty consult on the economic development corporation, and their mandates to make money for the band. And so let's take forestry, for example. If they want to make a deal with the forestry company, they're looking at maybe getting some jobs and getting involved in the industry or getting some revenues. But what about the single mothers that are collecting non-timber forest products, birch bark or whatever for crafts? And they need those values of the forest protected too. But the duty to consult of the Economic Development Corporation isn't to address that. It's the chief and council's responsibility to keep the duty to consult with the people and make sure all the household and the family interests are protected. You know, like those things, the families that you know still harvest and still need those things to survive. It's not just logging trees, that's just an example. But my point is there's a conflict of interest even within our own structures where we have economic development institutions. If we don't hold them in check as, you know, governments, you know, as chief and councils, then, you know, we're just helping to perpetuate the problem where our people are being alienated from the land base and being impacted by industrial development, whether it's forestry or mining or whatever. So I think we need the economic development institutions, but we need to keep them in check and not give them the mandate to do the duty to consult too. The leaders need to keep that and keep an eye on their economic development corporations to make sure they're respecting the duty, the people's interests too. So I just wanted to make that point.
Not to open up another can of worms, it's probably, when you look at free and prior informed consent, I think a lot of communities are going through this now, even with the Cannabis Act or the cannabis, and we ran into that in our communities where, you know, different First Nations are responding to it differently, not all the same, but I know in our community, we kind of put a hole on it, Chief and Council put a hole on it, but they were questioned. How come we weren't consulted? Some of the younger people were asking about that. Not only on behalf of themselves as young people who may be users, but on behalf of the older people who were had for medical use. And that was the way that Chief and Council created a dialogue. It was humming outside the walls. But I kept saying, just be patient, just be patient. Consultation will probably now happen because it's ideas are coming out. So now the people have to listen. So it's interesting because that was what was referenced by a young person is, how come I didn't get informed? How come we were the priority? And so forth. So that's another example, but within the community level. I just wanted to share that. But we have a young lady here. Hi.
Hi. So my question is, I'm just finishing my law degree now at U of T, and my law degree is being it's specialized in the duty to consult and accommodate. And when I was defending my specialization, my thesis was creating a policy to do accommodation Canada-wide based off Chapter 11 of the Yukon Umbrella Final Agreement and the Not-Too-Done Supreme Court case that came out last year. And there was a lot of pushback from the academics at the school saying that it was extreme to have an equal, consensual agreement for land use planning to the point where they didn't want to publish my paper until I calmed it down. So I guess my question is how to deal with that pushback in academia, and I didn't think it was that extreme. It was just going off of FPIC and UNDRIP and the idea of no veto powers and having consent. And so I guess from an academic and professional standpoint, how to deal with that pushback.
Fire your committee. I mean, I think that's unethical, to be honest, that they would push back on your legal rights as an Indigenous person that are recognized internationally, but also supposedly aspirationally being domesticated through Canada's system. So I'm surprised about that, and I'm happy to talk to you about it afterwards if you want strategies for navigating academia, because I've gotten pushback in academia as well, and I know other Indigenous students have for basically you're dealing with ignorance, I think, of people who think that they understand the legal system but don't really have an understanding of colonization.
You got time with the professional. Any other questions? Oh, here we go. Up in the front. Mike? There she is, right over here. This beautiful lady with the hat. Don't worry, she won't hit you with those sticks. She stopped. Ani Bojo.
Ani Bojo, I just wanted to say that I have a lot of Native friends in Toronto because I worked there for 29 years, and one of them was Cree Ojibwe, and we kind of chatted like about political science on Facebook, because he was in the NDP and I was with NDP a few times. But anyway, I just wanted to get back to what he said about why did the government fire all the chiefs in 2009? Like they pulled them all out of Ottawa, and that kind of upset us. Only a national chief. One chief.
Yeah, I'm not sure what, we're not sure what you're saying.
I just wanted to say that things are probably going to get better because my daughter works for the EIA, and she said she's working really hard, and she's doing really good. And she said she's like a social worker, sociological worker. She's JohnsonResearch.ca. She does these conferences too with 500 people. And teaches them how to calm down with laptops, no more laptop rage. But I just wanted to say that to be positive.
Absolutely.
I think if we look at the positive side of emails, like JohnsonResearch.ca, she has like a second page, it's like tools of how to say no to crystal meth, heroin, and drugs.
Oh yeah.
And I'm really happy that marijuana is legal, because I use cannabis on my shoulder. I've got really bad shoulders and knees, so I sit by lady doctor. So. Positive. Let's be positive.
Oh, mi wedge.
Cannabis instead of calling them all drug heads.
Well, that was, I just utilized that as an example for, at a grassroots level, but it'll be interesting to see how it goes when we talk about prior and informed consent. When we're asking to practice that, I think our grassroots people need to learn what that is also.
Since you brought up the cannabis example, I guess I commented on it a little bit. To me, that's another example of how the Trudeau government's not serious about this nation-to-nation relationship or reconciliation, because they didn't include First Nations in considering the development of that legislation.
That's right.
And even at the Senate, they had to go before the Senate, just before the Senate was going to vote on the bill. And they asked the Senate to give them 1 year to consult and come back to the Senate. Just let us pass the law, they said, because it was important to the Trudeau government, because that's one of his promises was to legalize cannabis. So the Senate said, okay, you can go ahead and pass it. Well, pass the law, but you need to come back to us and tell us how you're going to address the First Nations issue. In the meantime, what the Cannabis Act does is it offloads the regulation of cannabis to the provinces. And now, in a way, it's like gaming. Shawanaga went to court, and I believe it was at the Supreme Court level. They said gaming's a provincial authority, so you have to have an agreement. And it was bingo. Remember, they were saying that they had the right to run bingos without a provincial permit. So they ran that up the court system. The court said, no, gaming is a provincial jurisdiction, and you have to get an agreement with them. In a way, this cannabis bill, I look at it as like gaming.
Yeah.
It's basically province by province now. First Nations in the bands in the provinces are going to have to work out an agreement to be under that law. I mean, there is the sovereignty issue, and some are pushing that, saying we're going to operate dispensaries or whatever without the provincial permit. For example, Tyendinaga, I think, has a number of them. that are operating without a provincial permit because Ontario said there's only one online source to buy in Ontario. And I think Alderville's operating some. Oh yeah, Oneida, that's right. You're right. But I think the smaller communities are going to be more in threat because, you know, I can't see Doug Ford ordering the OPP to go and raid Tyndonega. But I could see him doing that to smaller communities who don't have the numbers. But I only bring that up because they said that they're going to go ahead and operate under First Nations jurisdiction. So they're not operating under the Cannabis Act, they're operating under First Nations jurisdiction.
And there's another example of Tier 4 government being placed at that level.
But nationally, I believe there's 2 bands in Manitoba that have made agreements with the Manitoba government. Because according to the Cannabis Act, if you want to grow, distribute, or sell, you need to be permitted by the province that you're in. So province by province, Nova Scotia, I think the bands there are going for it. But I've seen a few saying they're going to exercise First Nations jurisdiction. I think there's one band in Saskatchewan that said that Chief Lynn Akus, I saw her in the press saying that they're going to go ahead and do it under their own jurisdiction. So there are a number of bands that are saying to Trudeau and the government, saying, well, we're going to implement it under our own jurisdiction. We don't need provincial regulation or federal approval. So we'll see how they deal with that. But the point is, it does show that the Trudeau government, I don't think, is serious about this relationship because they knew that there would be impacts, but they didn't address it. And now it's each band is going to have to come up with their own strategy.
Exactly.
And that's what's happening.
Yeah. Miigwech. Vern has a question for us. Here we go. Ani.
Ani, am I on? I guess the discussion has been around sovereignty and to create that legal identity, because right at the moment our identity is listed under the Indian Act, because that's our identity under this legislation. And of course that means we are second-class citizens, and correct me if I'm wrong, but it's legislation that controls the Indian Act and how those different sections are put in place. The sovereign question is this, I guess, is more what I'm concerned about, and I think that we need to almost immediately look at developing some of our own internal, they call it knock-on-the-gate decision-making abilities. And that's where perhaps the election codes would come into play. I know that we might start off at an arm's length someplace else, but once we start developing something such as an election code, that would lead to other codes eventually building up that nationhood that we really need. I know that we discuss nationhood and we discuss sovereignty, but we seem to never get started anywhere. And I think that's the ultimate point here, is that we need to start someplace in order to gain that strength so that we can work against whatever the issue may be. Now, I was talking to Chris a little while ago, and I tried to get an answer from him, but this legal beagle that's standing up there, he just wouldn't answer my question. So I asked him, well, my understanding as a Anishinaabe person is that in my treaty area, we made a deal with the British government. We did not make a deal with Canada. I guess in a sense it was Canada because it was called Upper Canada because of pre-Confederation time. But in pre-Confederation Canada, it was the ultimate authority of the British government. So right now, our dealings should be with the British government, per se. And if it's one of those issues where free, prior, and informed consent come into play, does that statehood of Canada have any bearing on our authority or our identity as the so-called the British versus Anishinaabe agreement situation? Because that nationhood that once signed that treaty with the British government is struggling, trying to implement another identity within itself. It's the same thing as if you're trying to make a deal of free, prior, and informed consent with a municipality. Because what's a municipality doing trying to make a deal with a First Nation when they should be making other deals? And the same thing with us in terms of the British government. So perhaps a long question. I know about the British situation. I guess we should see what our legal minds up there think about that mechanism between the British authority and ourselves, because we're talking about sovereignty. And of course that sovereignty is going to hit that direction head on with the British and not Canada. Some viewpoints on that I would appreciate. Thank you.
You didn't ask me that. It was a lot shorter. I would have answered you then. I just teasing you, HK. Actually, he got me really thinking, and it's similar to what one of my students asked me in the grade 11 studies class that I was teaching one time, and we were researching. They had the same concept, because when Canada was establishing itself as a state, World War I, they had to put an army together to show, as a part of the definition of a nation, was, there's a definition of how you qualify as a state or a country. And one of them was military. And they had asked Britain for that lot of money that was being held, through the course of the dealings. And they sent it to the military department. And as we know, after the World War I, a lot of our men and women, they enlisted voluntarily. But I was trying to figure out the exact date and time that this actually occurred, but through our readings we found that. And what inspired that question was when APTN did that show where they took 5 individuals across to learn about indigenous people, is their whole framework of mind changed when they start to understand that the tax dollars were not being used for indigenous people. There was actually some money set aside. And various students that were doing research were finding these things and sharing this documentation. Now, the reason why I slowed down on you was because I can't really verify that transaction. So I said, we need to look for that transaction, with those dollars. Because as I was mentioning before, a lot of money has been held in trust. Where is this trust? Grassroots people say, trust, what's that? I don't trust them anymore. Because we had amalgamation in our community with Point Grundine, that joined Wacomico, and they almost got ripped off because the compensation they got was less than what it was actually, because they forgot they paid this compensation in miles as opposed to leagues. And there's a difference. League is a French term, which is 3 times a mile. On the other hand, we had a South Bay West band, Botea, the Mi'eok. They came and they lived right across the bay from the reserve, and they moved over and they amalgamated. There was $1 million held in trust for them, but it was never handed over. Where is that? So the same question occurred to me in regards to your question in regards to who we should be actually dealing with. You know, I think the British government wanted to wash their hands, but that's some of my findings, and that's a big question that we have all the time. But gentlemen, would you like to attempt to answer? Sure. Awesome. And then we're going to break for supper because I can smell it already.
We did rock, paper, scissors. So.
Okay.
I think that's it's a very good question. The legal response, I don't think, can really address it fulsomely because of the way our system operates. As some of you may or may not know, when Canada repatriated the Constitution in 1982, there was a case that went to the Privy Council in England, and not a lot of people talk about this case. But it was one of the issues in that case was what would happen with respect to the treaties if Canada did repatriate the Constitution, given that the Crown was ultimately responsible for those treaties. And the court there said, yeah, there has to be some ownership of that, and Canada has to understand that it's taking on those obligations for those treaties and that relationship. In many ways, that became the underpinnings for those discussions, some of which Russell talked about earlier. And it's not so much whether there's a legal remedy, because where would you go to get a legal remedy for that, right? You'd be looking, essentially your question almost goes to the heart of how the treaties have been basically alienated by the Crown and how those treaties have been breached. You can pick any example, any treaty across the country and identify where those breaches are. Even in the context of SON, our treaties with Saugeen and Nawash, we know where those breaches lie, and that's part of the basis of our title claim going forward. It's part of some of the individual claims each community has pursued over the years. Part of me thinks it's a political and it's one of those things that has to gather momentum right across the board from the communities all the way up, because you're right. You imagine a situation where your original treaty partner has handed off responsibility for their obligations to another party, and that party has failed miserably in honoring those obligations. What remedy do you have to fix that? And so, again, I keep coming back to these words that the Prime Minister used, nation to nation, and I keep saying, does he really know what he's saying? Because that's significant. When you think about even the rules in international law to recognize nations, we're not a conquered people. We never willingly relinquished our sovereignty and our jurisdiction, our authority over our lands. There are things that Canada did to undermine and erode that authority over time through the imposition of the Indian Act, residential schools, and so on. All of those things are inconsistent with our understanding of what those treaties meant. So, the big question, one of the big questions is there a legal remedy that can be had there? But I think part of me thinks it's more of and I don't want to say political, because I think it's the entire community. The communities themselves have to take ownership of that, because the treaty belongs to each and every one of us. And, one of the things I like that you've said, Vern, over the years is that you've challenged everyday Canadians as well. You said you are also treaty people. So every Canadian has a responsibility to those treaties and to ensure that those are being honored. And, you know, they're not. They haven't been. And there has to be an accounting for that. And that's why it's one of the principal calls to action in the from the TRC is to have those things reconciled. So very good question. Where the legal remedy is, it's very difficult. Suing government is not as easy as everyone makes it out to be, and it's a long shot at best. Sometimes you have success, sometimes you don't. Look at just what happened 2 weeks ago. I don't think you're going to find anyone who has expertise in the area of duty consult and accommodate is going to say that's a landmark case. That's a setback, a huge setback. And it goes to the very question, because really what the underpinnings at the decision war was, and even though they didn't say it, but this is what they were really saying, is we can't feather parliamentary authority. Because that would be acknowledging another sovereign, another nation. And we can't have that. And that's why I think the dissent is so important, because Bella said, wait a minute, you're either in or you're out on this honor the crown business. There's no sitting on the fence and picking and choosing when it applies. It applies all the time. And when you think about how Section 35 has worked, that's been a situation where over the last 30 plus years where our people have had to go to the courts and expend millions and millions of dollars in litigation to make their case. When you think about title claims, for example, it takes more than 19 years to get a case through to the courts. Delgamuukw was 19, Chilcotin was around the same time. You look at our case, probably around the same time frames. And the amount of resources that you have to go through to get there, maybe you get some success, maybe you don't, is astronomical. So when the court says, listen, there's no duty to consult with respect to legislation. Really, the underpinnings of that are we're not going to fetter parliamentary authority. And if you have a problem with the law, come back later and bring your challenge. What community has the resources to be able to do that? I think that's one of the problems inherent in our system is that communities have to invest that time and those precious resources to get that. And at the end of the day, no guarantee. You know, some folks might think it's out in left field, but I'm going to say it. I think that case just proves to me how alive and well the doctrine of discovery is in this country. And the justification that the courts have used. They don't say it, right? But that's the justification and the underpinnings of that case. So as long as those things are there, very much rooted in our legal system, part of me thinks we can't rely on that system for the justice and the reconciliation we need. I've always maintained that if you're in the courts looking for the reconciliation to happen, you're in the wrong place. So I think that's one of the things we got to pick that up and carry that forward and really determine for ourselves, what do we think sovereignty means to our people, to our communities and our nations, and how are we going to carry that forward? And I think once we build that strength and the momentum, that's how we start preparing ourselves for those larger fights.
Chimigwech. Nishin? Oh. Hey, who gave those people consent over there to go start eating? Okay. Okay, Shiri.
I know everybody's stomachs are rumbling, but I know there's one thing that maybe hasn't been discussed in depth that I want to just mention that I'm not going to go into in great detail because I know you're hungry, but that's the draft legislation that's on the table right now called Bill C-69, which is an act to amend the Environmental Assessment Act as part of the decolonization of Canadian law that Justin Trudeau promised on his campaign trail and through his throne speeches. And I think what's in that proposed legislation is extremely critical to think about, holding hands with what the Supreme Court is saying in terms of what the law and legislation is trying to pass through as consent. So in that legislation that governs environmental assessment acts that is now called Impact Assessment, the Impact Assessment Act, there is no mention of UNDRIP, and there is no mention of Indigenous consent. Mm-hmm. And this is the primary piece of legislation that governs some of the biggest conflicts between Indigenous people and the state, which is around resource development, extraction, and development. And the only mention of consent is around when pipelines cross through reserves. Mm-hmm. And so that signals that the only place where consent matters is when it's on reserves. So there is no mention of any broader traditional or treaty territory being taken into consideration as Indigenous land. Mm-hmm. And there's also dangerous things about who gets to make that consent on reserve as well. So if you're a grassroots person, forget about it. Your government is not considered what's called a legitimate Indigenous governing body under that legislation. So there's more I could say about that, but I just wanted to draw that to your attention as well.
Wow. Russell?
And I just wanted to add that the gentleman that was up here, who was the director of SON Environment, I forget.
Michael?
Michael, yeah. All the work that he talks about that SON is doing, this legislation is going to impact a big part of that work. So I don't know if there's been a legal opinion or anything for the bans here on that legislation, because AFN dropped the ball as far as I'm concerned. They were supposed to do a critical analysis of legislation and warn the chiefs when there's legislation that may impact on Aboriginal treaty rights. Mm-hmm. And there's been 11 bills that have gone through Parliament, and I haven't seen any critical analysis by AFN. So it really falls to the bands that can afford to do it, to analyze how is this going to impact us on the ground. And then, the burden is on them to say to Parliament, hey, we want this amended because it's going to impact us. And right now, that Bill C-69 that Shiri's talking about, it's almost through Parliament. It's in the Senate right now. So now they're talking about final amendments that the Senate may consider to send back to the House of Commons. So it's almost at the 11th hour. And I don't know how many First Nations have even critically looked at this. I mean, AFN didn't do it, so it comes down to the First Nations. Yeah. And then who can afford to do the legal analysis to say, how's it going to impact? But it will impact the two communities here, amongst others, right?
Yeah. April, Machad. Did you all feel guilty back there when I asked you if you asked for consent? No. We're going to wrap it up. Let's give these folks a big round of applause. Jimmy Wedge.